Hello, and welcome to the June 2026 meeting of Triangle Association of Freelancers. Our guest this evening is Mitch Tuchman, an attorney with the Morningstar Group in Durham, North Carolina. Mitch is going to be talking with us today about the legalities of writing about real people in fiction, essays, memoirs, and more. Before we get to it, though, let me read you a little bit about Mitch. A seasoned publishing lawyer, Mitch Tuchman helps authors and publishers develop mutually beneficial business relationships. He is a copyright attorney who has advised scores of authors and artists' estates, architects, photographers, filmmakers, educational and other nonprofit organizations, as well as publishers of print and online books with respect to the value and enforcement of their intellectual property, and has vetted manuscripts to identify legal risks associated with third-party claims. Folks, please welcome Mitch Tuchman. Mitch, it's all yours.
Okay, well, I sure appreciate that introduction. Um, yes, so I'm an attorney at Morningstar Law Group, and I have a long history with writing and publishing. I was a publisher at the Los Angeles County Museum of Art, and then got interested in copyright, went to law school, and never went back to the museum, and moved to Durham, North Carolina. And I get calls. The two principal things, the authors come to me for two principal reasons. One is they have been offered an author has been offered a publishing agreement, sometimes with a traditional publisher and sometimes with some variation of a hybrid publisher, and they want me to review the contract before they sign it. The other thing is that people write memoirs, once in a while fiction, but generally memoirs, and they refer to relatives or friends or people they hate, and they want to know what is the risk that they might be sued for defamation, and so they want advice on that. That's how this particular presentation I developed it. So maybe we should just get into it, and I will, you'll read the slides and I'll comment as we go along. So if you're all ready, you might as well do the next one. Next slide. So I'm looking at this from my NetDocs account. I'm not looking at it on the presentation. So is the next slide on living or dead, famous or unknown?
Yes.
Okay. Well, that's the real question. Can you write about real people in fiction or fact-based publications? And the short answer is simply yes, you can. You can do that. Next slide. Oops.
Okay.
So the the kind of legal basis of your being able to do that is the First Amendment of the Constitution. Everybody's heard of the First Amendment of the Constitution, and that limits it limits the ability of the government to prohibit certain expression. It has nothing to do with the relationship between private parties, but generally we kind of act as if the First Amendment is the permission for it's the protection for authors to write about real people. Let's go to the next slide. That wasn't very articulate, and I apologize for that. So this is the First Amendment, and I'm just going to read it. You can read it yourself. I mean, it's right there in front of you. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. And here's the important part: or abridging the freedom of speech or of the press, of the right of people peaceably to assemble and to petition the government for redress of grievances. But the part that's of interest to us tonight is abridging the freedom of the press. So this has to do with Congress making laws, but it has been extended to what courts can uh, courts are presented with these problems and they must obey the First Amendment as well. It's been extended through state laws and other federal law to permit free expression generally. So let's go to the next slide. So this is a brief one. So this confirms, yes, you can write about real people in fiction or fact-based publications. For the most part, for this audience, that probably means memoirs, but it might also mean any nonfiction writing. But it says, as you can see, yes, but the guarantee is somewhat limited. So let's go to the next slide. Your First Amendment rights do have certain limitations, because if you write about real people, they might object that you have harmed them in some way, and they might raise objections, and you might have to defend your right to write about them, to say the things you're going to say. They might sue you, and they might even prevail. So despite your ability to write, there are certain risks involved in doing that. So the next slide is I'm sorry, I have to advance. So, as I mentioned to you, people frequently come to me with concerns about risks, and they they often say, "Well, I'd like you to read my book, my manuscript." And I always tell them, "Don't ever ask a lawyer to read a book, because lawyers bill by the hour, and we're not all fast readers, and it's a very expensive proposition to ask a lawyer to read a book." So I always tell them, you're obviously calling me because you have particular concerns about things that you've said in your manuscript. So go through your manuscript and identify the portions that are of concern to you. That's all you should be showing me. Don't waste your money having me read an entire book and bill you for it, when 90% of it might not raise concerns. So um, if you go to the next slide, this is where it's the slide that's labeled risks. So when you write about people, there is a risk that you might defame them. You might make a statement that causes harm to their reputation or to their livelihood, or so they might claim. I mean, you might go to court and they're going to have to prove that they were harmed. They're going to have to prove that what you said cast them in a false light. If one of the examples of false light, well, let me back up for a second and distinguish for you defamation, which is illegally making a statement. Defamation is about making a false statement that harms someone. Violating a right of privacy and casting them in a false light or in a derogatory light, they're somewhat the same, but but defamation is all about the statement itself, and violating the right of privacy, which is similar but not identical, is all about harming someone. If you say that someone has a contagious disease, for instance, that might be perfectly true, but it also might be something that this person has been hiding that other people don't know about, and cast that person not in a false light, but in a light that might harm their ability to be in society, to be, friends. And I think that, for instance, outing someone that, in an earlier day, outing someone as gay when they were hiding it could be an invasion of privacy, even though it was not a false statement. So defamation and invasion of privacy are not exactly the same thing, although the harm that the victim suffers is probably largely the same. The other one that is not going to come up quite as often is violating the right of publicity, that is, using someone's name for commercial advantage, suggesting that they have endorsed your product or endorsed your book or endorsed your platform or something of that sort, when they have done nothing of the sort. That violates a right of uh, uh, a right of publicity. Let's go to the next slide. Here are more risks of which you need to be aware. When you sign a contract with the publisher, there's going to be a section, and this is true not only with traditional publishers, but even with hybrid publishers. There's going to be a section called representations and warranties. And you as the author will be required to sign a statement by signing the contract that says nothing in this manuscript violates another person's right of publicity or right of privacy or any personal right. And you don't actually want to sign it in that form, but that's the risk that when you sign a publishing agreement, you are going to have to not only sign something saying, I represent that nothing in my manuscript is defamatory, but you're also going to have to give an indemnification that says, but if there is anything defamatory and the damaged person, comes forward and sues, that you, the author, will pay the legal expenses of your publisher. So there's a lot riding on this, and that's one of the reasons why you want to be darn sure you're avoiding defamation. So I did have a client who was writing about animal rights, and she was highly critical of organizations that claimed to be protecting animal rights, but there was a certain amount of hypocrisy there. And she was taking statements off the internet, statements that she could not back up. She was not really in a position to say these are truthful. And I kept telling her, don't do that. Don't do that. Don't quote anonymous sources. You must be able to back up your statements. Let's go on. I'm trying to find exactly. So if someone comes forward and says, you have defamed me, what are you going to do? If the statement that you made, if you can show that the statement you've made is actually true, that's a defense. the burden is going to be on the person who feels slighted to prove that the statement is false. The burden is on them. And if you can show in response that the statement is actually true, that's a defense against defamation. But that's why you want to be darn sure you've done everything you possibly can to establish the truth of the statements that you make in your manuscript, because things may come back to haunt you if you don't have plenty of proof that a statement is actually true. The other is a statement, another defense, not nearly as ironclad, is a statement of opinion. In my opinion, uh, it's so easy to refer to Trump. He's such an easy target. But in my if you said, in my opinion, Trump represents, the worst of authoritarian, anti-democratic thought or something like that. That's a statement of opinion. It can't be, your opinion can't be tested for its truth or its falsity. And so couching things as opinions in your manuscript rather than as statements of fact is one way to protect yourself. If you're going to write about people, it's prudent to ask them for their permission, but sometimes that's not a good idea, because what if they say no? And then what are you going to do? Are you going to flout their denial and go ahead and publish, whatever you had in mind to publish? Uh, that it puts you in a very funny position, but it is, of course, the safest way to get permission, and get that permission in writing, in something that's signed. Um, Also, if you're writing about public figures, politicians, let's say, or celebrities, their burden of proving that they have been defamed is higher than if you're writing about your, siblings or something like that who are not famous. So a celebrity or famous person has to show that you made a false statement with the actual intention to harm them, with malice or with negligence. And uh, so that kind of also helps to even the playing field for you, by if you said something but it wasn't negligent, you said it but you had made your best efforts to gather evidence of the truth of what you were saying, then um, your lack of malice or your lack of negligence might be important in the course of the lawsuit. Of course, you never want to be in a position of defending a lawsuit. You want to avoid litigation, and so you want to avoid the risks to the greatest extent possible. But you never really know if someone is going to be offended and sue you. It could happen, you know. Um, I'm going to stop for a moment and see if, rather than just plow forward, if there are things that are not clear or that you'd like to ask about.
Sarah?
So I'm in the final stages of a memoir where I'm about to go through the literary review with a literary attorney. Um, so there are multiple people who may have their feelings hurt, but my question is, in the defenses, does it protect you in a lawsuit if you've completely obscured their identity, you change their appearance, their name, you don't even say the location you were at when this happened? If there was still, like, for this one case, someone could look at Google Scholar and see what university I went through if someone was really going to try to figure out who this was. But like, how much does it protect you in court if you've like completely obscured their gender, their name, their appearance, where they're located, but somehow someone figures out who this person was?
Well, I mean, what you're talking about is kind of fictionalizing uh, the person, and then the burden is on them really to prove that they themselves were the source of your your characterization, and that someone they're going to have to prove that they were harmed. That's part of a lawsuit. They have to prove they were damaged, and if the connection between your character and that person is so obscure that the public would never draw that connection, their burden of proving damage is greater. All of this, in the course of a lawsuit, there's a lot of what we just always refer to as he said, she said, and the so there are no ironclad protections, uh, and I can't tell you the quantum of change that is necessary to protect you, but all of that will come out in the give and take of a trial. But I don't think there's anything that you can do that will prevent someone from suing. If that person is, if any person feels he or she has a claim against you, then they can sue, whether they have a good case or a bad case.
I think what I have going for me is that she's been retired for a while. She is a she might be a public figure. And shoot, if she sued me, then I'd turn around and sue her for discrimination and workplace violence. So, I mean, maybe I would, but I mean, but um, that's the thing I'm most worried about.
Yeah. And chances are in that situation where you're both vulnerable, potentially, that's when the parties and their attorneys sit down and come to some sort of settlement. And
Yeah,
uh, but there is no foolproof defense that is a bar uh, against a claim.
okay. But I that's a great suggestion about the statements of opinion. I think I'm going to preface many things as my opinion, and I think that's a good tip. I appreciate it.
Yeah. Okay. Well, I hope that's helpful.
Mitch,
Um, I
Mitch,
can't remember if there's a slide in here about disclaimers. Disclaimers are not, they they tend to suggest I certainly didn't mean to harm anyone, but they're not in and of themselves legal statements or defenses. So don't rely too much on, how movies will always have something that says the characters in this movie are fictional. Any similarity between these characters and anybody living or dead is purely coincidental. Well, that's that may or may not be true, and even if it is true, um, it's not a legal defense. It's just saying I sure didn't mean to harm anybody. It might go to the issue of negligence or malice, but it wouldn't go to the issue of did you make a defamatory statement or a false statement.
Mitch, before you continue, Joel was curious if there is a legal standard for malice.
Um, I can't recite anything to you. You really have to go to the cases. And the thing to keep in mind is defamation law and invasion of privacy law is state law. There are 50 states and I don't know how many territories, and they all have, they may or may not have laws regarding uh, not only what constitutes defamation, but what constitutes malice. But there will not be one standard that is applicable in 50 states. And usually the standard that prevails is the law of the state where the offended person resides.
Oh, okay.
So
Great.
sometimes people will come to me and say, here's my manuscript. And, I ask them, the person or persons of concern, where do they live? Because we can't give you the law for 50 states. What we can do is give you the law of the state where the potentially offended person resides. But you don't want to pay a lawyer to do a 50 state review of defamation law.
Thank you.
Sure. I guess we can go to the next slide. And it should say de Havilland versus FX Networks. Is that what everybody's seeing?
Yes.
Yeah.
Okay.
Yeah.
You may or may, I did not see it myself, but you may recall that there was a TV series, or I guess it was a short series, not a whole season, about Truman Capote and half a dozen very wealthy women who used to be his friends. And just a second, I have the wrong, I'm going to back up. I'm giving you the wrong information. This was a series called Feud, and I want to be sure that I'm doing this correctly. One of the episodes was the feud between Betty Davis and Joan Crawford, and another was the Truman Capote one. And I've now somehow gotten confused in my mind, but the actress Olivia de Havilland was portrayed in one of these. It was in one of those series or the other, and I apologize for forgetting which it was. In any case, she was portrayed, we think of her as sweet Melanie in Gone with the Wind, and this portrayed her as, in her real life, being not that sweet character at all. And she and her sister, Joan Fontaine, were notoriously antagonistic. And in this TV show, de Havilland was shown saying very critical things about her sister, and she objected that they were not quotations, they were not things that she had actually said, and she sued and she lost, because it's very hard to prove defamation. It's not an easy thing to prove. And but I like to cite this case because while I don't really expect that you will all look it up on the internet, and if you find the decision, which is not hard to do, if you will read the whole thing. But I've rarely seen a decision that gives a clearer and more extensive summary of what First Amendment rights can and cannot accomplish. And that's what that's why this case is so important for anyone in this field. And the court says, no one has a legal right to control, dictate, approve, disapprove, or veto a creator's portrayal of actual people. That's what this decision against de Havilland ended up saying. And now this was, of course, famous people. And the court basically said, if you can't show that yes, the author might not have quoted you correctly. Yes, the author may have invented a scene for whatever convenient dramatic purpose. But if you can't show that this was done not in the service of fiction, but in the service of actual malice, you're going to lose. You're not going to prevail. And that's what happened to Olivia de Havilland. She sued over her portrayal, and she lost. So here's a little more. If you go to the next slide, this is the standard that the court in the de Havilland case came up with. Publicity that places a person before the public in a false light that would be highly offensive to a reasonable person, and where the defendant knew or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the plaintiff would be placed. And in the case of this TV show, yes, they showed de Havilland as having a waspish personality and calling her sister something. It wasn't really that awful, something like the Dragon Lady or something of that sort. And she didn't want people to know that in real life she was not like Sweet Melanie for God with the Wind. That was what really bothered her, that this falsified the reputation that she had spent her life creating, even though it was not the truth. I mean, she was a mean, evil person. That's all there was to it, So it's an important case because it really shows you how tenuous the whole notion of defamation really is. By the way, North Carolina does not have a right of privacy statute, and also, by the way, New York, where there are so many celebrities, does not, I believe, have a right of privacy statute. What they do have is an abundance of cases that were decided by courts. It's called common law, but it's in the absence of a statute. North Carolina has very weak laws when it comes to rights of privacy, defamation, and rights of publicity. And I used to think it was kind of humorous because I've only been at 2 law firms in my entire career, but at the first law firm, which was at that point called Womble Carlyle, one of our attorneys tried one of the first cases claiming, I think, a right of publicity in the absence of a statute, and lost. It always seemed funny to me that the decision that established there was no such right in North Carolina was lost by one of our own attorneys. But that's okay. Let's go on to the next slide. This was a memoir. This was a case of a memoir by a doctor in North Carolina who was writing about medical school and residency. And he had a lot of critical things to say, especially in the residency portion of his memoir. It was really well written. It really was a well-written book. And but he had a lot of things to say. Now, he was not sued, but he wanted me to look at the manuscript to alert him to any obvious risks of defamation. And as I mentioned, there's no federal law at all. It's all state law. And we looked at North Carolina law, and we were pretty much able to assure him that he had not done anything or said anything that put him at risk. But it's good to remember that even though North Carolina has no defamation statute, it certainly has judge-made law, or what's called common law. So that if you go to the next slide, in North Carolina, courts have determined that a claim of defamation requires that a statement be published, that it be defamatory, and that it be about the plaintiff. The plaintiff has to come forward and prove that the author published a statement that was false and concerned the plaintiff. So those are the elements of the claim. If we go, let's go to the next slide. So what is a defamatory statement? It's demonstrably false. It tends to harm the reputation of a person so as to lower him or her in the estimation of the community and deter other persons, third persons, from associating or dealing with him or her. And it's possible that a person will be able to claim monetary damages and say, I was harmed in this amount. You know, my business disappeared because of statements they made about the way I conduct business or the quality of my work. And if those statements were untrue, then there's, you know, a quantifiable monetary damage. It's not always possible to prove a monetary damage. It might be possible to prove emotional distress or damage of, you know, intangible damage. Not always possible to prove actual monetary damages. So what we were able to say to our client, this doctor who was at that point probably, I'd say he was in his late 30s or early 40s. So he wasn't even in the middle of his career. He wasn't just starting out, but he, you know, he had many years to go. And we were able to look at the statements that he himself identified as concerning, as representing a risk of defamation or a risk that someone might come forward. And we were able to assure him of what I've been telling you sort of over and over again this evening, and that is that the truth of the statement is a defense against defamation, and statements of opinion. And this is what his book was. I mean, he was talking about someone being an awful person. That's a statement of opinion, and not either provable or unprovable. And those are generally not actionable. Could we go to the next slide? So if the plaintiff says, Well, you were negligent in making that statement. You didn't make an effort to establish its truth or establish that it was true or false. And so the plaintiff doesn't have to prove that you intentionally lied, but only that you had a disregard for the truth. And so keeping journals of what you've done, what is the basis of a statement you've made, how did you prove it, what were your sources, all of that will be very helpful to prove that you were not merely negligent and disregarded the truth, that you did your best to establish the truth of a statement or to establish that something was an opinion and not a statement of fact. And that was how we sort of reassured this particular client of that he could go forward. He asked, as do many clients, well, what if I use a pseudonym? And one of you asked that this evening. But to the extent that other details in a manuscript, after all, the person who's complaining is going to be your most diligent reader. That person is going to look for other evidence in your publication that would make it possible for members of the public to figure out, who he or she is. So merely changing people's names is probably going to be inadequate, and that's a calculated risk. I can't believe I have so much to say about this this particular book, but one of the things I had mentioned before, that if you sign a publishing agreement, you are going to be asked to sign representations and warranties, and they will say the author represents that nothing in the manuscript is defamatory. And I always make an effort, and usually successfully. In fact, I did this just today for a client. I always make an effort to insert something into those representations that says, to the best of the author's reasonable knowledge, nothing in this manuscript is defamatory. Because, well, first of all, it's hard to prove what your reasonable knowledge is. But what you really want to say is, if there's anything defamatory there, I didn't know it. It's a matter of, coincidence, or, I made my best efforts, but it's that is not going to stop an angry person from suing, but it might, having that statement in there, to the best of the author's reasonable knowledge, might deter the publisher from forcing the author to pay the publisher's legal costs. Because after all, who is this person going, the offended person, is the offended person going to sue a writer who might not have any money? Or is he or she going to sue the publishing company, which is far more likely to have assets? And that's why the publishing company forces you to make this indemnification. And that's why you push back and say, to the best of my reasonable knowledge, nothing here is defamatory. But as I always say to publishers in these situations, we have to have this so-called knowledge qualifier because of the way libel and privacy are proved in court, which may or may not have a malice standard. most of the time the publishers don't have any idea what I'm talking about. And so they will go along with my request that our client only be forced to defend statements that were made, defamatory statements that were knowingly defamatory. But
Oh, God.
it's a matter of what the jury or the court might decide. I mean, the author may have no intention of defaming someone, but if the court or if the jury thinks that's not the case, defamation might be found. So we do whatever we can at the contract stage to minimize the author's risk. And if you're handling these things on your own and not coming to a literary attorney, just remember so much of what's in this in the contract you're about to sign is a matter of allocating risk either to the author or to the publisher. And what you want to do is deflect the risk and make it the publisher's risk and not your own. Sometimes possible, sometimes not possible.
Mitch, is everything we've talked about this evening as applicable to online writing as it is to print
Yes.
publication?
Yes. You know, defamation is not limited to print media.
Okay, thank you.
Yeah, sure. Are there other questions? Because I think I kind of hope we've exhausted the memoir. It was such a good book. I mean, that guy really did a good job. And, you know, this was the only case I can remember where the author identified some passages and said, okay, if you want me to show you what I believe is risky, here are the pages I think are risky. But I liked the book so much. I read the whole book. I just didn't bill him for my time, you know, but it was such a good book. I read it anyway. And so
Should we go to, you want to go to group questions, Mitch?
we can go to questions. There are only a few more slides, but yes, why don't we see if there are questions at this point? And I'll get a drink of water.
I've got a question.
Joel?
Yeah, and this is somewhat embarrassing, or possibly not, but it actually is not directly on publishing. If someone says something defamatory about me and they're in another state, and I guess, you know, the question you just mentioned that North Carolina has very few privacy laws, and that it would be a matter of being sued. The person who would sue under their own state laws. I had somebody imply that I was a child molester, which did piss me off.
I would think so.
But they simply said it in a text to one of my relatives.
Aha.
And
yeah.
You know, I'm thinking to myself, and aside from the complication of simply, you know, causing family upscuttle, but I found it interesting to what the defamation laws had to say. And we were talking about publishing, but this was simply something where, you know, is gossip also publishing, or if it's texting to one of my relatives, or what?
I'm not sure how a court would decide. There are two kinds of defamation. There's written defamation, which is called libel, and there's oral defamation, which is called slander. And what the question you're really asking is this libel or slander? I would think that it's libel. It was written. and it was published in that the person who made the accusation about you put it in writing and made it available to someone else. To me, it sounds like libel. And it would be, I don't, when you think about the cost of initiating litigation, it might just be so prohibitive that you would never seek to enforce your right to be free, to not have your reputation damaged. But I had someone come to me just yesterday who, he had gone to a hybrid press and he was disappointed with his royalties. He thought they must be withholding something because I can't believe how little I'm earning. And
he hadn't been in publishing long.
Yeah, and I didn't say this to the person, but the question really is, if your book has a potential to earn, let's say, $1,000 in royalties, are you really going to spend $50,000 to collect that $1,000?
Right.
So sometimes you just have to walk away from it and find some other way to deal with it.
Sarah?
So you've described how an individual can claim defamation. There are instances in my memoir where there is no way that anybody could know who actually said this to me, but the institution where it was said, like a medical school or a university. How does the law apply to like an institution? Is it the same principles?
I don't I am not aware of cases, at least in North Carolina, where an institution was the defendant in a in a defamation case.
Because yeah, it really only said about this individual. I don't think it really reflected the institution, but I was just curious if there's ever been cases of an institution suing for defamation.
Oh, so that the institution is claiming to have its reputation damaged. I think the answer to that, although I can't cite you any cases, I think the answer to that is likely yes. Entities other than individuals probably, it seems to me probable that institutions or entities have felt that they've suffered harm and sued. And for instance, let's say that you resurfaced a reflecting pool in the nation's capital and it turned green, and it really wasn't anything that you did wrong. It really was vandals. I mean, regardless of what the actual facts are. Now, if it was vandals, but everybody blamed the company, and nobody's going to hire that company anymore, so their business is toast. Can they sue the vandals? Well, they could probably sue them for some sort of business harm, but of course, this actually, now that I think of it, this is such a poor example because we don't have any defamatory statements or anything like that. We just have the possibility of a false accusation. So,
Yeah, I think the safety would be it would be really hard. It would be almost impossible for an institution to prove damages because of anything I say. So I mean, to me, that would be a protecting factor that an institution would have to prove that damage was done.
yeah, and as a practical matter, are they really going to, they would have to have been grievously damaged before they would dedicate resources to litigating a claim of that sort, it seems to me, just as a practical matter.
It would probably be bad PR too, you know?
To sue,
Yeah,
yeah.
to sue an individual after they've been through so much or something, you know?
Yeah, I mean, sometimes the party that is suing ends up shooting itself in the foot because it's Goliath suing David, and everybody is sympathetic to David. It's like that woman who did a video of her child dancing to I think it was a song by Prince, and the record company sued her for copyright infringement. And of course, even though she did literally infringe, she came out to, as Robin Hood, and the offended copyright holder came out looking like the sheriff of Nottingham. So it can turn around and be harmful to the plaintiff.
Does anyone else have any questions for Mitch? It's hard for me to see you, so
Yeah,
just,
well, all I'm looking at is a slide deck.
yeah, I see that too.
I don't
So
see any of you, you know.
just yell out if you've got a question. Nobody? Okay. Well, Mitch, thank you so much. This was absolutely wonderful. We really appreciate this. It was really informative and really insightful, and we appreciate your time and your expertise.
Oh, it's wonderful. I'm going to close
Thank you.
I'm right now I'm going to close my PowerPoint, and unless I really screw up, I think I'll be back to the conference. I hope I'm doing this correctly. Goodness knows, I hope I'm doing this correctly.
I guess I did have one more question.
Please.
Mitch, do you what is your backlog? Like if there was a contract reviewed, are you like a month or two out from?
Oh, goodness, no.
Okay.
It's very funny. Sometimes several days will go by and the phone doesn't ring. And I think, oh my goodness, I guess I should just retire. And nobody's calling me. Nobody knows I'm here. And someone called, what is today? Today's Wednesday.
The 24th.
Yeah. So someone called, I think it was on Monday, and asked me to review her publishing agreements. And I said, how just tell me, how did you happen to find me? And she said, I just asked AI. So as long as there's an AI out there, I guess people will find me. But it takes several hours to review a contract, but it doesn't take several weeks. It takes several hours, and that's all there is to it. So, my capacity is more or less limitless.
Okay. That's good to know.
What do
Thanks.
what do you charge an hour, or what's a reasonable rate that any copyright lawyer?
Like, I always try to clarify that. I don't charge. The firm charges.
Yeah,
The
okay.
firm charges $460 an hour. And
Okay.
I wish I could tell you that I make $460 an hour, but that's not true. They keep the lion's share of that.
Mitch,
So
I'm sorry. Go ahead.
I don't know what other firms bill. I think if you're in New York, it's more expensive.
Did you accept arms and legs?
No. I don't do flat fees or contingency, which I told someone just this morning, and I didn't hear back from that person. Another one that we got yesterday was someone saying, I'd like a 1 hour consultation, and here's a list of the things I want you to tell me. And I told our office manager, this is not something that we should be dealing with, because I can tell this person what I know about copyright and trademark law. It'll probably take more than an hour, but I can do that. And then the person's going to go off and attempt to represent herself. And if things go south, she's going to blame me. Well, I don't know. You know, I said, no, I don't want to be involved in this. I'm happy to represent people, but I'm not going to tell them, this is what the law is. Go take care of yourself and don't come back and blame me if it blows up in your face. Yeah.
This is the part of our meeting where we kind of share our good news, people who have, had something good happen, sold a piece or found a new market.
That's wonderful.
And so I'm going to start. I'm happy to report that earlier this week, or no, late last week, I got another assignment from Writer's Digest. I'm doing an article on how to write a killer lead for your article. So I'm very excited about that. That's going to be a lot of fun. And also, I wanted to note that I mentioned this early on to some people, but I'm reading Susan Orlean's memoir called Joyride, which is about her life as a writer. I'm only just starting it. I'm only a few pages into it, but I'm already in love with it. It's an absolutely remarkable book, and I can't wait to finish it. So I'm going to be dropping some nuggets to the group, just some points that she has made, some, nuggets about writing that I think are good. I'll share those with the group. So that's my good news. Does anyone else have anything to share? Sarah?
I've had a lot to say today. Sorry. Now my book of sonnets, called My Soul to Keep, Faith in the Midst of Suffering Leads to Deliverance and Praise. Its publication date is July 15th. It's with Prolific Pulse Press with Lisa. And I'm going to try to I'm trying to arrange a book launch for Sunday, August 2nd. So I will keep everyone posted. No pressure, but I'll just send an invite out, and anybody who wants to RSVP that they're coming, that'll help us figure out how many people are coming. So I'll have an RSVP thing set up on my website, so you can just click if you're coming, so we can know how many people to expect. So, but I'm
Keep
really
us
excited.
posted. That's awesome, Sarah. Congratulations. I'm excited about that.
Thank you.
Yeah, let us know when you do the signing.
Absolutely.
Does anyone else have anything to share?
Wish I did.
All right. Well, I want to welcome Melanie. Melanie is a new TAF member. She joined just recently. Melanie, tell us very quickly, tell us a little bit about yourself.
Oh, okay.
What
No
writing do you
pressure.
do?
All right. By day, I'm a nurse, and but I've loved writing my whole life, and I've spent over the last few years, I've been building my writing practice, and I write daily. I have not been published yet. I have received a couple of rejections, and I'm thinking of trying to write something to submit for Omnibus. And
What do you do?
yeah, okay.
What kind of writing do you do? Fiction, nonfiction?
Fiction. I mean, I also kind of like the personal essay prose type stuff. I mean, I feel like such a novice in the company of all of you, but I was really happy to have been referred to the Right Now conference and joined that day, I think, or the day after. Really impressed with what you all do. And
Thank you.
I absolutely love writing, and congrats. I can't wait to read your article. Writer's Digest, super exciting. And congrats on your book. I'm very happy to be here. So
It's wonderful to have you. Welcome to the family. Let's put it that way. And I
nice.
encourage you to take advantage of our listserv, Melanie. If you have any questions about any aspect of writing or publishing, we've got a great brain trust of people with decades of experience. So don't hesitate to reach out if we can help you in any way.
Thank you so much. I'm still figuring out the tech side of how it works. Like I get email and I don't know that I'm really connected to the Google part, but I'll reach out about that and ask some questions if I don't
Please
figure
do.
it
And
out.
if you have any questions, email me directly and I'll help you.
All right. Thanks so much.
Awesome. It's great to have you. It really is.
Thank you so much.
Is anyone else?
Don, I just want to thank the people who filled out the membership survey. And I want to let people know the membership survey is still open until midnight tonight. The planning committee for right now, 2027, will be getting together in July. And if you want to, if you haven't yet, please fill out that survey to give us recommendations of speakers or subjects so that we can include that in our planning process.
And that
Yes.
email is from you, Tara? So the email's from you if I was to look in my inbox and stuff?
Yes, I sent it to
Okay.
the group and it has a QR code. And if you're not familiar with how to use QR codes, there's a brief video on how to use it to access the survey.
Okay.
We really want your information and your opinions on this. So please take a moment to fill it out. We'd really appreciate that. All right, I guess we're good to go then. This was an awesome meeting. Mitch, thank you again for
Oh,
joining
it's a
us.
pleasure.
It's always great to have you. We loved what you
Nice.
did for us at the conference. It was just wonderful. It really, really was. I hope we can have you back again sometime.
Happy to.
I hope you have a
Thank
great
you.
evening. And
Okay.
everyone else, I hope you have a
Mhm.
great evening. We will see you again at the end, last Wednesday of July. We're working on a presenter, but I've got some thoughts, and if it pans out the way I hope it will, I think that you will like it a lot.